Hello, and welcome to Williams Mullen's Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, trademarks, copyrights, and trade secrets. I'm your host, Janet Cho, and today I will be joined by my colleague, Ed White, who is a partner in our intellectual property practice group here at Williams Mullen, and we will be discussing the Digital Millennium Copyright Act, or the DMCA, and its takedown and safe harbor regime. Ed, how are you doing today?
Good, Janet. How are you?
I'm doing very well, and I'm really excited to have you back on this podcast. I know that we did a previous podcast discussing the benefits of DMCA for copyright owners and online service providers. So I'm really excited to get back into this subject matter and talk about takedowns and safe harbors and really get into the details. So it would be helpful if maybe you can start with right where we left off, is how an OSP or an online service provider may be eligible to take advantage of the safe harbor regime.
Sure. Yeah, I'm happy to do that. And I'll just give you a brief overview of the flow, and then we can maybe drill down a little further into each of the steps. But absolutely, I mean, the DMCA, as we talked about in our last podcast, is a great vehicle if you are a copyright owner or if you're an OSP, an online service provider. In the case of the copyright owner, it enables you to get an expeditious takedown completed if there's infringing content that's up. And as an OSP, obviously, you can avoid contributory liability if you do things properly. But that's really the key. If you're going to take advantage of it as a copyright owner, you need to make sure that your takedown request is compliant with the DMCA. And if you're going to take advantage of it as an OSP, you need to make sure that your takedown procedure is compliant with the DMCA. So just briefly, what's going to happen is normally an OSP receives a complaint from a copyright owner or their designated agent. The OSP then needs to take expeditious action to take that infringing content down. If they do that, there may be a counter notice issued by the potential infringer, alleged infringer, who posted the content in the first place. And if that is a compliant counter notice, that information or that material can go back up. And at that point, the copyright owner and the poster or the user who's filed the compliant counter notice can work together, those two parties, to basically take care of the dispute without the OSP needing to be involved. But again, everybody has to do it properly.
And that's very helpful. And I will say one of the things that's come up a lot, I think, for at least online service providers or those who have an internet presence, is the phenomenon of third parties or unknown parties essentially cloning or copying your website and placing it somewhere else. So your website is essentially appearing elsewhere, perhaps with your brand or even a different brand. And so I know that for content owners, they're definitely interested in takedowns, how that happens. So in order to make my takedown request compliant, what are some of the things that I need to include to make sure that it's consistent or compliant with DMCA?
Yeah, sure. And absolutely, you've hit the key there, Janet, that if you want to take advantage of the expeditious takedown, you need to make sure it's correct, your takedown request as a copyright owner. And what you'll find is that in some websites, they may provide you a form that includes all of the information I'm going to talk about, which makes your life easy. But in other ones, it's not so easy. It's not so clear. So as a copyright owner, you really want to kind of commit some of what I'm going to talk about, I guess, to memory or write it down so that you're making a compliant request when you're issuing that takedown request to an OSP. So first and foremost, you need to make sure you're identifying accurately the copyrighted content, the works that the copyright owner claims have been infringed. You also want to identify to the OSP the material that's been infringed and provide the OSP sufficient information to locate that infringing content on its website. If it's a posting, perhaps you give them the number of the post. Maybe you send them a link, etc. But you want to really spell out for them where it is. You also want to provide the contact information for you, the copyright owner, or your designated agent, whether that be at the designated agent you have at the Copyright Office or the designated, I won't call it agent, but the person through whom they should work within your own organization on the takedown request. You also need to provide, as the copyright owner, a statement that you believe in good faith that the allegedly infringing material is not authorized by the copyright owner, or the agent can make this statement as well. That statement should be under penalty of perjury. And in the same realm, the complainant should be asserting that the owner is authorized to act on behalf of the owner of the copyright, that the agent rather is, or that the owner is acting in their own right and that they have exclusive rights under copyright law to make the infringement claim. And then finally, as the complainant, you need to provide your physical or electronic signature to the OSP as the copyright holder or the agent for the copyright holder.
And that all makes sense. And to some extent, it sounds very consistent with trademark-related complaints, the kind of information that you might have to submit for a trademark complaint online. That said, especially for complaint scenarios where the information that's required is not defined, what happens if I make my complaint and it's actually non-compliant?
Yeah, sure. So we have actually represented OSPs as well as copyright owners. And as OSPs, even the OSPs who want to make sure they're doing this right, that becomes difficult for them because there is no requirement for them to act necessarily on a non-compliant takedown request. If it doesn't comply, then basically there's no admission that the provider had the necessary knowledge to take down the infringing material. Likewise, though, they're sort of in a bit of a no man's land at that point. So what they really ought to do, the OSP under the DMCA, is reach back out to the notice provider and take some reasonable steps to let them know that they're missing some information or they need perhaps a bit more information to fully resolve their takedown request. And if an OSP makes those reasonable efforts and the complainant still doesn't provide a notice that's DMCA compliant, then at that point, essentially, I think the OSP can move on, secure in the knowledge that they've done what they could. There's no requirement for them to do more. And certainly, they've been good corporate citizens and good IP citizens.
That makes sense. And in the case of takedown requests that are actually compliant, so let's say that you have done everything you needed to do, or the complaint that you filed is defined by a form provided by, the OSP. If my takedown request is compliant, then what should the OSP do? What are the next steps from there?
Sure. So if the OSP receives a DMCA compliant takedown request, then they should expeditiously move to remove that content from their site. That's the next step in insulating themselves under the safe harbor provision from liability. Once that takedown is done, there's an opportunity for them to advise the party who uploaded the content that they've taken it down. There's not a requirement, and this is a little bit of a gray area here for them to do that. But if they choose to do that, and especially in some business contexts, they want to do that because perhaps, let's say someone's uploading content and the nature of the business is such that the OSP makes their revenue from repeated uploads of content. Well, you might have somebody who inadvertently is infringing content, but they're a good customer. So all the more reason why you may want to reach out to them and let them know that, in fact, you have taken down the content.
Well, I think that makes sense. I think that would be, for our listeners, one of the things that would be really interesting to know is there a requirement to notify the party who uploaded the content that's the subject of the takedown? But kind of going to the other side of the transaction, so for the party who posted the content, what is their recourse? Are they able to file, a rebuttal or maybe what we call a counter notice? Is there an opportunity for that?
There is. I mean, if you're giving them the opportunity to file a counter notice, or some are just frankly adept enough at the DMCA that they notice immediately the content has been taken down and you actually just receive a counter notice. But there most certainly is a process for that if they think you've gotten this wrong. And in the same way we said that there needed to be certain information included in your takedown notice to have it be DMCA compliant, Likewise, to file a valid counter notice under the DMCA, there's certain information you need to include. And so let me go through that. The first is you need to an identification of the allegedly infringing matter that was removed and where it had been located. So again, you're pointing out to the OSP where it was removed and where it had been located prior to removal. Second thing you want to do is a content poster in this counter notice is to provide a statement, and this has to be under penalty of perjury, that you believe in good faith that the allegedly infringing matter was removed as a result of a mistake or misidentification. In essence, you think it was a mistake, perhaps the copyright owner was mistaken or misidentified material that shouldn't have otherwise been taken down by the OSP. You'll also want to provide your name, your username, address, and phone number. You'll need to consent to jurisdiction in federal district court where the user is located, the poster is located. And if the poster is located outside the US, well, then where the OSP can be found. So in essence, what you're doing there is you're setting it up so that the OSP can push this dispute to be resolved by the actual parties. You'll also need to consent to the service of process in anything that's sent to you or served upon you by the copyright owner. And you need to provide a physical or electronic signature when you provide all of this information. Now, unlike a takedown notice where if it's not fully compliant, you may still want to go that extra mile as the OSP to ask for the additional information you may need or to put them on notice that perhaps it wasn't compliant. With regard to a counter notice, there is no statutory obligation under the DMCA for an OSP to inform the user that there are defects in their counter notice. But here again, even though there's no statutory requirement that you do that, certainly if it's a good customer, the user, you still probably want to reach out to them and let them know that perhaps they're missing something here or there. At the end of the day, I think that a good rule of thumb, maybe a golden rule, is to do your best to help the copyright owner and to do your best to help the potential infringer so that they can take advantage of the takedown and the counter notice provisions.
Thank you, Ed. That was really helpful in understanding in detail the takedown process and what both the content owner and the user might experience in all of this and what is their recourse and what they need to do to essentially state their position. So that's been very, very helpful. And I think it will be helpful for our listeners as well. And that will actually wrap up our discussion about the Digital Millennium Copyright Act, takedowns, and the safe harbor regime. I'd like to thank my colleague Ed White for joining me on Trending Now, an IP podcast. If you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find out more about our team as well as past episodes of this podcast and legal alerts. Please be sure to subscribe to this podcast to be notified when our next episode posts. Thank you so much for listening, and until next time.